When someone passes away, their bank accounts can become a complex issue for loved ones left behind. It might seem simple to inform the bank about the designated beneficiary, but in reality, accessing these funds often involves more steps. Typically, beneficiaries need to provide a death certificate and may have to go through probate court depending on the account type and state laws. The reality is that accessing a deceased person's bank account isn't straightforward. It typically requires extensive documentation, such as a death certificate and probate court orders if the account was solely in the deceased person's name. The process may involve waiting several weeks or even months for approvals from banks and other financial institutions. This complexity arises BEC, a USE Chinese letter 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 Chinese letter. First things first, when someone dies, their assets do not automatically transfer to anyone else. All accounts are frozen until the legal process known as probate is completed. This means that no one can access those bank accounts, even if they're named beneficiaries in a will or trust agreement. The only way around this freeze is through specific documents and court orders related to the probate process. Let's say you need money from the deceased person's account to pay for funeral expenses. You might think going directly to the bank would be simple, but it is. To get access, you'll likely have to file a petition with the local probate court, requesting them to release funds specifically for these expenses. This is a legal process that can take several weeks. Now imagine trying to handle other bills and debts left behind. You might think your spouse or children would automatically inherit everything by law. However, that's not the case. Even if you're married and the account was jointly held, the bank will still require proof from probate court before releasing any funds. This can delay payments and cause real financial stress for everyone involved. To make things even more complicated, each state has its own rules about how to handle this process. Some states have simplified procedures called small estates or informal probates, which can allow quicker access under certain conditions. But you still need the correct paperwork and court approval in most cases. In other words, there's no one-size-fits-all solution. So why is it so difficult? The answer lies in legal protections and regulations designed to prevent fraud. Imagine if anyone could simply claim someone was dead and take their money without proper proof. This would lead to numerous problems, such as unauthorized access to funds and the potential for identity theft. So banks are required to follow strict protocols to ensure they're not being duped, which can include verifying death certificates, probate court orders, or other official documentation. However, this also means that loved ones often face significant challenges in gaining access to a deceased person's bank accounts. This situation can be particularly stressful and frustrating, especially if immediate financial actions are required. Here's a real example. Mary had an account with her husband Joe, and it was set up as a joint account where either could make withdrawals. When Joe passed away, the account typically transfers to the surviving owner automatically by operation of law, meaning Mary should have been able to access the funds directly without going through probate court. However, complications can arise from bank policies or errors that might temporarily prevent her from accessing the account as expected. And here's another one. John's mother had a sizable checking account that wasn't set up as a joint account or with designated beneficiaries. When she died unexpectedly, it took several weeks for her son to gain access to the account to pay her final bills and funeral expenses, despite providing all required proof of identity and relationship documentation. This isn't just about delays, it's also about costs. The probate process can involve significant expenses, including legal fees, filing fees, and various administrative costs. These charges can accumulate rapidly, potentially running into thousands of dollars depending on the size and complexity of the estate. Now let's talk about some ways to avoid this mess in the first place. One option is setting up a revocable living trust. This allows you to designate someone as trustee who can manage your assets after you pass away without going through probate court. It's more complex and may involve higher upfront costs, but can simplify asset management and distribution later on. Another solution is ensuring that all important documents such as wills, trusts, and durable powers of attorney are in place well before they are needed. These should be updated regularly, and it's crucial to inform all relevant parties about the location and details of these documents so that everyone knows where to find them when necessary. Now here's something that might surprise you. Even if you're listed as a beneficiary on an account, it doesn't automatically give you access right away. You typically need legal proof from probate court or other official documents to claim the assets. This is why having proper documentation in place ahead of time can save weeks and potentially thousands of dollars later. But there are some exceptions. If the deceased had less than $50,000 in assets, the limit varies by state, with some having higher thresholds. You might qualify for a simplified small estate process. This usually requires submitting an affidavit, a sworn statement, along with proof of death to release funds more quickly and without full probate court involvement. Now let's take a closer look at the actual steps typically involved in accessing a deceased person's bank account. Step 1. Obtain a certified copy of the death certificate. The first step in accessing a bank account post-death involves obtaining a certified copy of the death certificate. This document is typically available from the local Vital Records office or health department within a few days after someone's passing. Subject: bank account access post-death. Step 2. Notify the bank and financial institutions once you have obtained the death certificate. Notify all relevant financial institutions about the passing. This includes banks, credit card companies, investment firms, and any other places where the deceased held accounts or assets. Step 3. Obtain legal proof from probate court to gain access to funds. You'll need to file a petition with the probate court requesting the release of specific amounts. For urgent expenses like funeral costs and bills, you might qualify for an expedited process if your state provides it. Step 4. Fill out required forms. Each bank will have a specific set of forms to complete once you obtain legal documentation from the court, proving your right to access the account. These forms often include affidavits verifying your identity, your relationship to the deceased, and your entitlement to the funds in question. Step 5. Pay any fees associated with probate. As mentioned earlier, probate can be costly, involving legal fees, court filing fees, and other administrative expenses that can accumulate quickly. Be prepared to cover these costs out of pocket unless the estate has sufficient liquid assets available initially. Now let's dive into a bit of financial psychology here. The stress of dealing with a loved one's passing is already overwhelming enough. Adding the complexity of navigating legal procedures to access their bank accounts can make the situation even more challenging. However, there are practical steps you can take to simplify the process. Keep important documents organized. Maintain all important documents, including wills, trusts, and power of attorney forms, in one easily accessible location. Designate beneficiaries on accounts. Whenever possible, designate beneficiaries for bank accounts and retirement plans to ensure funds transfer directly upon death without going through probate. Set up a revocable living trust. This can help avoid the need for full probate and allows someone you trust to manage your assets according to your wishes after you're gone. Now here's where things get interesting. The exact amount of money involved isn't always as critical as it seems. For example, an account with $50,000 may sound substantial, but funeral costs, estate administration fees, legal expenses, and other charges can reduce that sum significantly. So while having easier access to funds might seem more convenient, the real key is minimizing unnecessary delays and maximizing immediate access to funds for urgent needs post-death. Now let's talk about some numbers. According to a study by the American Bar Association, the average cost of probating an estate in the U.S. can vary widely depending on complexity and state laws, ranging from $1,500 to over $30,000. That's money that could be going towards settling bills or providing comfort for grieving loved ones instead. But here's the kicker: if you plan ahead properly, much of this can be avoided. Setting up joint accounts or naming beneficiaries on bank accounts and other financial instruments, as well as establishing a comprehensive trust, may seem cumbersome initially but can save significant stress and costs in the future. So what does this mean for your own future? It means preparing today to avoid complications tomorrow. Take the time and spend the resources to set up proper legal structures now, rather than dealing with headaches and delays when something happens. In short, proper planning ahead can prevent a lot of unnecessary hassle and expense for your loved ones when you are no longer around. Now here's one last thing that might surprise you. While many people think probate is solely about distributing assets to heirs, its primary purpose is actually to ensure legal and fair handling of the deceased person's affairs. It's designed to protect everyone involved, including the deceased, potential heirs, and creditors who may have claims against the estate. But this protection comes at a cost in terms of time and complexity for those left behind. That's why having a solid financial plan with clear beneficiary designations is crucial, as it can make all the difference during difficult times. So remember, while you might think your bank accounts are straightforward, they can become one of the most legally complex areas when someone passes away. Planning ahead can help avoid costly delays and stress for your loved ones later on. This is educational and historical, not financial advice. Here's a crucial point many people miss. Even with clear beneficiary designations on certain accounts, some banks may still require probate paperwork for verification purposes. It's like having a key but needing additional confirmation from a locksmith to ensure it fits before opening the door. For instance, if you have a joint account with your spouse and one of you passes away, the surviving spouse typically has immediate access to the funds without any issues due to the right of survivorship. However, sometimes banks may still request death certificates or other documentation as a precaution against fraud. It's like having a secret code, but needing an administrator to confirm before granting full access. Another common scenario involves retirement accounts like 401(k)s and IRAs. These typically have designated beneficiaries who can inherit them under certain conditions, though not necessarily tax-free. If these designations are outdated, or if the bank isn't notified properly of a beneficiary's death, it could delay access to the funds while probate processes unfold. Think about it, having the correct beneficiary information on file can save weeks or even months of delays and headaches. That's why spending an hour reviewing and updating your financial paperwork acts as a safety net, helping to prevent potential issues before they arise. Imagine if you were planning a big vacation, but suddenly found out that all necessary travel documents had gone missing. It would be frustrating, right? The same applies here. Having everything in order beforehand can mean the difference between smooth processing and unexpected delays when it comes to accessing your loved one's accounts after their death. This is educational and historical, not financial advice.